New Zealand has the highest rate of domestic abuse per capita in the developed world. Abuse needs silence to thrive. In this series, Simone Butler, herself a survivor of a vicious attack by her ex-partner, meets those brave enough to break their silence.
I have been forced by the family court into a co-parent situation with a man who has abused me for years.
I think that the dysfunction of the family court is one of New Zealand's worst kept secrets. This is a court with deeply entrenched dysfunction, with these stereotypes, entrenched with these misunderstandings. I think we need to shut the court down.
The relationship quite quickly turned into a really abusive relationship. It was frightening. He would hit with his fists. If we were in the car, he would hit my arms or my legs. If we were at home, it was often my head. He would strangle me. He would hit my head against the wall. And one time he knocked my teeth out. He intimidated me and he stood over me.
At what stage did you know that you had to get out?
I decided once we'd had our son. I realized that there was no way that I could allow a baby to be in an abusive situation. I left the relationship, and it was hard to do, but I did it. I set myself up in what I thought was a safe space. After that, life got worse. He phoned multiple times a day. He texted me over and over. It was all day, often all night. There was never any respite. It impacted my ability to eat, sleep, work, be a good mum. There was nothing I could do or say to make it stop. I was pretty convinced that something really, really awful was going to happen. I thought that he was going to either kill me or kill our son, or both. The only way for me to make this stop was to go find a lawyer, which I did, and then ask the family court for a protection order. I was granted a no contact order. I felt protected by it. It was the only thing after years of abuse that was keeping me safe. And then he contested the order.
It's pretty well documented that the personnel of the family court don't have an evidence-based understanding of family violence. They definitely don't have an evidence-based understanding of risk assessment or child safety. They don't like to issue protection orders because they don't want the protection of the victim to interfere with the perpetrator's contact with the children. In the family court, they have myths and they have misunderstandings. One of the just pervasive myths is that children will suffer more harm if they don't have extensive unsupervised contact with a violent father than if they are exposed to additional violence. The evidence is overwhelming from health studies that exposure to violence is devastating for children. There is no evidence, and I mean no evidence, to suggest that losing extensive unsupervised contact with a violent father leaves children worse off. Another myth they hold is that post-separation, the risk to children goes down. It does not, it goes up.
They tend to separate violence that happens to the mother versus it happening to the child. They'll see it as, well, that has nothing to do with the child. The child should still have an opportunity to be with that abuser.
What actually happens is that you arrive at the court and there's a waiting area, and the man that has abused you for many years is right there. You can see each other. At no point did anyone check in on me to make sure I was okay. Sitting there in the most vulnerable place with a man that terrified me, and no one asked me if I was okay. Then the lawyer for child starts going back and forth to negotiate things about our child access arrangements. What time I should be allowing pick up and drop off without any discussion about safety. It was nothing to do with the protection order, and this was all outside of the courtroom.
Often the lawyer for the child and the lawyer for the domestic violence perpetrator will in fact kind of collude and gang up on the victim. She's awaiting a protection order hearing, and they are using her anticipation for the hearing as a form of soft coercion to wear down her resistance.
They were asking me to hurry up, make a decision, sign that. They were writing things down on pieces of paper that I couldn't even read. The lawyer for child said, "We want you to agree that you will drop the protection order and accept an undertaking." And then she said, if you refuse to drop the protection order for yourself, you should at least drop the protection order for your child. I thought, what kind of person would I be to ask for protection for myself, but not ask for protection for my child? What kind of mum would that have made me? So I said no.
At any time, a perpetrator can turn lethal. And in fact, one of the most high-profile cases in New Zealand is the Bristol case. Christine Bristol had sought both a no violence and a no contact order against Alan Bristol. He had an extensive history of physical, psychological, and sexual violence against her. The Bristol girls had a lawyer for the child who filed a memorandum with the court, basically saying to them shared custody was eventually inevitable, and so it would be against the best interest of the girls to grant Christine the protection of this no contact order. These 3 little girls were murdered in the court-ordered care of their father.
You don't just have to prove that the violence and the emotional abuse and the stalking and the harassment has happened. You have to prove an ongoing need for protection.
Did you have any evidence of the ongoing harassment?
I had spent the last 18 months keeping every single text, message, call record, email, notes, police call-outs. There was hundreds and hundreds of pages. I remember saying to the lawyer for child, how much worse does it have to be for you to support a protection order? Her reply was, the violence and the abuse is now deemed historic by the court.
This word historic is a word they use in the family court to minimize family violence and to minimize the ongoing risk that a perpetrator poses to victims. But whether it eventually goes away or not is dependent on the systemic response that the victim gets.
Then his lawyer said that if I went into the courtroom to ask for the protection order to be made final, they were going to go after me for costs. And they also made other threats around our son's custody arrangements. I ended up spending all of my savings. It was $65,000, having $25,000 worth of debt. I was pretty close to not being able to put food on the table. They had me in a corner. I thought, I need all of this to stop. I can't afford it. Which I know seems insignificant when you're talking about safety. But when you're trying to keep a roof over your head and feed your child and function, I didn't feel like I had any choice at that stage but to accept an undertaking. So I did. You have to walk into the courtroom and there's a judge. I was screaming inside. I remember trying to catch the eye of the judge. I remember being so desperately scared at that point that I thought, if he just looks at me, I can communicate how frightened I am. I can shake my head, or I can show him that I didn't want to agree to this. He never looked at me. There was no eye contact. I was in there for 3 minutes, 4 minutes. I just felt like I'd been abused all over again. I couldn't quite comprehend what had just happened.
Part of what we don't talk about enough is when kids are ordered into the contact or into the care of a father they're afraid of, it's the mother the system makes deliver them. So from the point of view of these kids, the person who used to be their safe harbor is now the ultimate betrayer of their trust.
It's very difficult dropping your child off to a man that you know can be so violent and so frightening. But there's no choice.
Children will tell their mothers, I don't want to go, and then not being able to do anything about it. Women tell us how difficult it is for them to, as a parent, to hear your child say that to you.
I'm still a victim of domestic violence. He's still a perpetrator of domestic violence. And I'm forced into a situation where I have to now drop my child off with my abuser. There's no protection. I'm back where I started.
My personal opinion is time is up. If you're serious about a specialist institution, you have to build it from scratch. You have to staff it with people with multidisciplinary, evidence-based expertise in mental health, in substance abuse, and most of all, in family violence. The UN has said that the family court is systemically hostile to women and children who've experienced violence, that they systemically prioritize men's rights to contact over women and children's rights to safety. There comes a point in time where you have to say, this court is broken. In New Zealand, 50% of women will experience domestic violence in their lifetime. 50% of children will experience child abuse or neglect. 40% will be sexually abused before their 18th birthday. I mean, the scope of this problem, the prevalence of family violence in this country, deserves a court system that is equipped to deal with it appropriately.